Under U.S. citizenship law, Zivotovsky is a U.S. citizen by birth. He can even run for president if he wants, although he was born out of the country. The following December, Menachem's mother Naomi went to the U.S. Assembly in Tel Aviv requesting a passport for Menachem and asked that his place of birth be listed as Jerusalem, Israel. Naomi's request was denied. The issue at hand was not whether Menachem's birthplace was in dispute. He was born in Jerusalem. It was the second geographic place that triggered the dispute. Is Jerusalem part of Israel, part of Palestine, or is Jerusalem neutral ground? The U.S. Supreme Court arguments in Zivotovsky versus Clinton in November 2011 was a case that examined whether Congress had the authority to pass a law in September 2002, just 1 month before Menachem's birth, instructing U.S. officials to list Israel as the place of birth on passports for those American citizens born in Israel who requested. Up to that point, and since Israel declared independence, federal law required that U.S. citizens born in Jerusalem could have only Jerusalem listed on their passport and not Jerusalem, Israel. The purpose of the policy is to avoid taking sides in the ongoing Arab-Israeli conflict over the status of Jerusalem. Both Israel and the Palestinian National Movement claim Jerusalem as their capital. But the city was divided in 1949 following the war that broke out after Israel declared its independence. Israel has controlled Western Jerusalem since then, and it occupied East Jerusalem nearly 2 decades later during the 1967 Arab-Israeli War. Israel later annexed the eastern part of the city, although neither the United States nor the United Nations recognizes the move. The U.S. government's position has long been that Jerusalem's status must be resolved as part of Israeli-Palestinian peace negotiations, which are now dormant. The U.S. State Department policy reflects this neutrality. Can the State Department regulate how places of birth are listed on passports, even though Congress passed a law that was signed by President George W. Bush saying otherwise? The question put before the Supreme Court was, in many respects, over 200 years old, because it focuses on core elements central to the design of the U.S. Constitution, specifically separation of powers, checks and balances, and legislative supremacy. The notion that the lawmaking branch is supreme over the executive branch, which is what the Constitution's framers intended. The framers' intentions are seen in that Congress is listed in the first of 7 articles, and Article 1 is the longest of the constitutional articles. While the Supreme Court was asked to rule on these larger questions, the issue that brought these questions to the court is caught up in U.S.-Israel relations. Does Congress supersede or otherwise limit the State Department's purview to decide how places of birth are listed on passports? In this instance, those passports belong to U.S. citizens born in Jerusalem and not elsewhere. It is critical, though, to take a few steps back and ask the big questions. Why is there a dispute in the first place? And why is the U.S. Supreme Court the arbiter in mediating that dispute? Stepping back requires that we recognize that the U.S. Constitution does not give the Supreme Court judicial review the power to interpret what the Constitution means, and thus to declare federal and state laws and executive actions unconstitutional. While judicial review is considered the greatest among the Supreme Court powers, the power was given by the court to itself in an 1803 case that dealt in some ways with many of the same issues central to Zivotovsky versus Clinton. What are legislative and executive powers, and from where are those powers derived? Article 2 of the U.S. Constitution gives foreign relations powers to the President, which include negotiating treaties and receiving public ambassadors. Taking these points together, Congress, an extension of the people, had the power to enact the Foreign Relations Authorization Act, a provision of which suggests that Jerusalem is part of Israel. As poll after poll shows that most Americans support Israel when asked which side of the Israeli-Palestinian conflict they back, Congress's decision to pass this measure cohered with public preferences. Zivotovsky versus Clinton was an appeals case that had already been heard by 2 federal courts before the Supreme Court decided to hear it. The Supreme Court rejects appeals cases 99% of the time, which made the court's decision to hear Zivotovsky versus Clinton back in November 2011 highly unusual. Now that John Kerry is Secretary of State and not Hillary Clinton, the case name has changed to Zivotovsky versus Kerry. How did the Supreme Court decide less than 2 weeks ago on June 8th? As most of us already know, and as was discussed in the heritage delivered to our mailboxes yesterday, the court sided in a 6-3 decision with the State Department, and by extension, with President Obama, whose position on Jerusalem's geopolitical place agrees with his predecessor, President George W. Bush. In siding with the State Department, the court held consistent with prior cases that the executive branch enjoys sole power to conduct foreign affairs. Put differently, the Supreme Court found that Congress has the supreme power to make laws, just not this one, at least not Section 214, on the grounds that Congress has no authority to recognize foreign governments, which would include the birthplace of young Mr. Zivotovsky. And it is notable that of the 6 votes favoring the president's position, 3 of those votes were cast by the 3 Jews on the court, Justices Breyer, Ginsburg, and Hagan, all Democratic appointees. Critics of the decision suggest that it is a major blow to a 13-year-old effort to bolster Jerusalem's status under American law as an undisputed part of Israel, while the White House issued the following statement. We welcome the Supreme Court's important decision in Zivotovsky versus Kerry, which reaffirms the long-established authority of the President to recognize foreign states, their governments, and their territorial boundaries. The Court's decision upholds the President's long-standing authority to make these sensitive recognition determinations as part of his conduct of diplomacy and foreign policy. Moreover, it confirms that the President's recognition determinations should be accurately reflected in official documents and sensitive diplomatic communications, including passports. The President's position was that the law encroached on the President's power to conduct foreign affairs and would, if enforced, undermine the U.S. government's claim to be a neutral peacemaker in the Middle East. The majority opinion authored by Justice Anthony Kennedy recognized the President's power to recognize sovereignty claims and that the passport issue falls within that presidential prerogative. Chief Justice John Roberts, who cast one of the 3 minority votes, suggested that the majority viewpoint brings the court into unmarked and treacherous territory. According to Roberts, the court takes the perilous step for the first time in our history of allowing the President to defy an act of Congress in the field of foreign affairs. Still, both President Bush and President Obama agree on this point, that the legislation takes power from the President duly extended to him by the Constitution. What are the implications of this case? The decision does not impact whether Menachem Zivotovsky and the approximately other 50,000 U.S. citizens born in Jerusalem will be able to travel with a U.S. passport. The fact that the focus of this case is an unsolved and age-old question means that these questions, which will remain unsolved and only get older, have brought to light the nature of U.S. government process, which, while messy, provides an excellent civics lesson, especially within the context of how separation of powers and checks and balances are intended to work within the U.S. constitutional framework. Shabbat Shalom. We will now continue with the Musaf service, Judy Chistis will lead us. We will begin